This case disappears today.
I have sat on this bench long enough to recognize patterns before they announce themselves. Decades in this courtroom have taught me that authority is not volume or threat, it is consistency. Every day I weigh liberty against safety, and I do it knowing that one careless decision can follow an innocent person home. That burden never leaves me. I have presided over thousands of cases involving fear, loss, and consequence. I have watched people arrive angry, ashamed, frightened, or convinced they were untouchable. The law treats none of those emotions as excuses. My duty is not to reward confidence or punish attitude. My duty is to protect the public by applying the law evenly, without favor and without fear. Experience has stripped me of impatience, not judgment. I listen carefully because listening exposes truth faster than pressure ever could. I keep my voice measured because control in this room sets the standard for everyone else inside it. When authority becomes emotional, justice becomes fragile. This court exists to draw lines that power prefers to blur. I am here to hold those lines steady. I have faced politicians, executives, and influential families who assume proximity to power altered responsibility. It never has. It never will. Public safety is not an abstract principle to me. It is the pedestrian trusting a crosswalk, the officer enforcing a law, the worker expecting fairness. Every ruling echoes beyond these walls. That reality demands restraint, clarity, and resolve. So when a case enters this courtroom carrying entitlement instead of accountability, I do not react. I prepare. Because calm authority is strongest precisely when it is underestimated. My role is to stand firm, record facts, and ensure that no name, title, or influence ever outweighs the simple obligation to answer for one's actions under the law. I did not need a briefing to understand the environment this family came from. Their name carried weight long before it entered my courtroom. Public office, private wealth, and constant access to influence had formed a protective shell around them. Problems were managed quietly. Consequences were delayed, softened, or redirected toward someone else. From an early age, the individual before me had learned that rules were flexible when applied to the right surname. Authority figures were obstacles, not boundaries. Institutions existed to be navigated, not respected. That conditioning does not happen overnight. It is built through years of exemption, approval, and silence from those who should have drawn limits. The family's resources insulated them from ordinary exposure to risk. Security handled discomfort. Advisors handled damage. Lawyers handled blame. When mistakes occurred, they were framed as misunderstandings rather than warnings. This pattern teaches a dangerous lesson, that accountability is optional and consequences are negotiable. I have seen this background many times. Privilege does not create malice by itself, but unchecked privilege erodes restraint. It replaces caution with confidence and humility with expectation. Over time, contempt grows for systems designed to protect people without power. What concerned me was not the wealth itself, but the absence of friction it created. Without resistance, behavior hardens. Without limits, judgment dulls. By the time this case reached my bench, entitlement had already shaped every interaction. Respect was assumed upward, never offered outward. This context matters because it explains the posture that followed. The court was not viewed as an equal authority, but as another venue to manage. That assumption, born from lifelong protection, set the stage for defiance that would soon move from attitude into action, with consequences far beyond reputation. And this history made escalation predictable, once scrutiny replaced accommodation inside this courtroom today. The incident arrived before introductions, carried by footage and testimony. It involved public space, moving vehicles, and a clear disregard. This was not private misbehavior hidden behind closed doors anywhere. People without warning were placed at immediate risk by actions. Lawful instructions were ignored as inconveniences rather than safeguards intended. The individual acted with confidence that consequences would not follow. Witnesses described shock, confusion, and fear spreading within seconds nearby. Public servants attempted intervention and were met with dismissal immediately. No apology followed, no hesitation, and no concern for outcomes. What stood out was not speed, but the attitude displayed. Authority was treated as optional and safety as else's responsibility. This behavior carried weight because ordinary people lacked protection nearby. Children, workers, and commuters shared that space unknowingly at risk. I have seen accidents and I recognize precursors immediately there. Recklessness paired with entitlement accelerates harm faster than chance ever. This incident crossed that threshold without hesitation or remorse shown. The courtroom exists to respond before tragedy finalizes outcomes permanently. That purpose brought this case directly under judicial review today. Danger was measurable, documented, and connected to deliberate choices made. Nothing about it required interpretation or dramatic framing from anyone. The facts spoke clearly through evidence, timing, and witness accounts. This was the moment concern shifted into formal accountability proceedings. Public safety demanded attention beyond status, comfort, or reputation alone. The law intervenes precisely when confidence replaces caution entirely dangerously. I noted the posture presented even before testimony concluded fully. There was expectation, not reflection, and impatience toward restraint shown. That combination signals future risk, if uncorrected by the court. Courts act to prevent repetition, not merely respond afterward passively. This incident justified scrutiny because lives intersected with arrogance publicly. It marked the beginning of a necessary judicial response process. After the initial incident, I expected caution to follow. It did not. Subsequent reports showed the same disregard repeating itself in different settings. Warnings were issued, conditions explained, and expectations made clear. None of that altered behavior. Instead, confidence hardened into defiance. The pattern became undeniable. Similar conduct occurred again, placing people at risk without necessity or justification. Each occurrence carried the same signature: impatience with rules, dismissal of authority, and reliance on status as protection. This was not impulsive error, it was choice. Public servants documented their attempts to intervene. Each attempt was met with resistance or indifference. Compliance was treated as optional and restraint as an insult. The repetition elevated concern from isolated danger to predictable threat. When conduct repeats after instruction, it signals intent. I considered whether education or misunderstanding played a role. The record answered that question. The individual understood the rules well enough to avoid consequence when convenient, and ignored them when confidence outweighed caution. That selective obedience exposed the risk. What escalated this case was not severity alone, but persistence. Every repeated act increased the probability of harm. Public safety does not depend on luck. It depends on boundaries being respected. When boundaries are tested repeatedly, the court must respond. At this stage, plausible deniability collapsed. Patterns replaced excuses. The court could no longer assume correction would occur without intervention. Repetition transforms misconduct into warning. It tells the court that without firm accountability, the next incident will not be theoretical. It will be measured in injury, damage, or loss. That reality required escalation from observation to decisive judicial attention. I weighed restraint carefully, knowing authority must be proportionate. Yet restraint without response invites repetition. The record showed no pause, no adjustment, and no concern for those exposed. Each repetition tightened the timeline toward harm. That progression left the court responsible not only for judgment, but prevention before irreversible consequences arrived for innocent people nearby. I listened as the record shifted from risk to consequence. The people affected were not abstract figures or statistics. They were ordinary citizens who expected safety as they went about daily life. A public employee performing routine duties was forced to react under pressure. An elderly pedestrian altered their path out of fear. A parent described pulling a child away from danger without warning. These accounts mattered because they carried no agenda. They were not seeking attention or advantage. They were responding to conduct that disrupted their sense of security. When privilege ignores boundaries, it is never the powerful who absorb the impact first. It is the unaware and the unprotected. The human cost became clear through small details, shaken voices, missed work, lingering anxiety that followed people home. These were not dramatic injuries, but they were real. Safety is not only measured by physical harm, it is measured by trust in shared spaces. Public servants involved described hesitation where none should exist. They questioned whether intervention would be respected or challenged. That hesitation increases risk for everyone. When authority is tested publicly, it weakens protection for those who rely on it quietly. What troubled me most was how preventable this was. Ordinary people were placed in harm's path because restraint was dismissed. They had no choice in that exposure. They did nothing to invite it. This section of the case stripped away status and reputation. It forced the court to confront who bears the burden when entitlement overrides caution. Justice does not exist to smooth discomfort for the privileged. It exists to shield those without influence from unnecessary danger, and the record showed clearly who carried that weight here. That reality defines the court's responsibility in moments like this. The law must center those least able to defend themselves. Accountability restores balance when power disrupts it. Ignoring harm would signal permission for further risk, and that outcome is unacceptable to this court, this community, and the standards I noticed the shift when the focus moved away from facts and toward access. It did not arrive loudly. It came through assumptions, through quiet confidence that this case could be softened. Schedules were questioned. Procedures were tested. Familiar names were referenced without being spoken. There were expectations that time alone would dull urgency, that patience would become permission, that discretion would lean toward accommodation. None of this was stated as a demand. It was presented as normal. Counsel carried themselves as if resolution was a matter of negotiation, not judgment. The posture suggested that influence had resolved similar matters elsewhere. Resources were available, connections were understood. The implication was clear, even without words. This is where the case crossed a critical line. The issue was no longer only misconduct. It was an attempt to bend the institution meant to respond to it. When money and position are used to redirect accountability, the law itself is challenged. I have seen this before. Pressure rarely announces itself as pressure. It arrives dressed as efficiency, cooperation, or courtesy, but its purpose is the same. It seeks exception. I addressed it directly and calmly. The courtroom does not belong to families, offices, or donors. It belongs to the public. No influence enters this room without being stripped of power. What escalated concern was the persistence. When subtlety failed, expectation hardened. That progression confirmed intent. The court could not allow precedent to be rewritten by entitlement. Drawing a boundary here was not symbolic. It was necessary to preserve trust, fairness, and the separation between justice and privilege. Allowing that would signal weakness to every observer. It would tell the public that influence speaks louder than evidence. That outcome damages more than one case. It corrodes faith in the system. I will not permit that erosion, because once it begins, restoring confidence becomes far harder than enforcing accountability at the moment it is required by the court, without exception or compromise, under law always, applied. I delivered the sentence the way a court should, slowly, clearly, and without drama. The record established repeated dangerous conduct, refusal to follow lawful direction, and a pattern of contempt that increased risk to the public. My responsibility was to respond in proportion to that risk, not to the family name attached to it. First, I addressed the core violation and the immediate public safety threat. The court imposed a term of custody appropriate to the seriousness of the conduct and the repeated nature of it. This was not a symbolic penalty. It was a consequence designed to interrupt behavior that had already shown it would not stop on its own. Second, I ordered strict supervision conditions upon release. That meant compliance checks, travel limitations, and a clear prohibition on behaviors connected to the prior incidents. Any violation would return the matter to this court with harsher consequences. Structure is necessary when self-control has failed. I also required surrender of any driving privileges for a fixed period, with reinstatement only after verified compliance and evaluation by this court. Third, I imposed financial penalties tied to accountability, not comfort. Fines and fees were set at a level that could not be treated as a casual expense. Restitution was ordered where measurable costs were documented, including damage and verified losses. Fourth, I required remedial steps that reflect responsibility, safety education, community-based service connected to public risk, and regular reporting. These conditions are not humiliation, they are correction and proof of change. Finally, I stated on the record what this sentence means. It means the court recognizes the harm created, the danger repeated, and the attempted pressure applied. It means privilege did not purchase a different outcome. The consequences were assigned because facts demanded them and because the public deserves protection. When I finished, the courtroom was quiet, not because of intimidation, but because finality carries weight. In this room, accountability is not negotiated. It is imposed, recorded, and enforced. I end this case without celebration. Justice is not a victory lap. It is a standard maintained when pressure fades. The sentence now stands, not as punishment alone, but as a boundary restored. Authority means little if it can be purchased, delayed, or softened by status. What gives the law strength is restraint paired with resolve. I exercised restraint by listening fully and weighing each fact. I showed resolve by refusing exception once the record was clear. Those two qualities must exist together, or neither serves the public. This courtroom does not exist to humble individuals. It exists to protect communities. When power challenges that purpose, the response must be calm and firm. Equality before the law is not a slogan. It is a practice repeated daily, especially when it is uncomfortable. The lesson here is simple. Influence may open doors, but it cannot rewrite responsibility. Wealth may buffer inconvenience, but it cannot erase risk created for others. Titles may command attention, but they do not command outcomes in a court that honors its duty. Public trust depends on consistency. People accept decisions they dislike when they believe the process is fair. They withdraw when they sense favoritism. Every ruling sends a message beyond these walls about what is tolerated and what is not. I leave this record with clarity. Accountability was applied without anger. Compassion was considered without surrender. The result stands because facts demanded it, not because authority insisted upon it. Society asks its courts to be steady when voices grow loud. That steadiness is how institutions endure. Justice survives only when citizens expect it to be equal and judges insist it remain so. That expectation, met with discipline, is how order is preserved and freedom protected for everyone. I do not measure success by applause or outrage. I measure it by whether tomorrow feels safer for those who follow the rules today. When the law holds firm, behavior adjusts. When it bends, harm multiplies. This court chooses firmness, not force, and clarity, not fear, so the public can trust the line will hold. Across time, that promise sustains liberty and responsibility together for every generation to come.